I don't know anyone who likes paying taxes. It's just one of those things you have to do as an adult. But contrary to what some people say, not all taxation is theft. We delegate to government, both state and federal, the power to tax, but that taxation has limits. So when does taxation become theft? Now, this case was filed by Michael Pung, representing the estate of Timothy Scott Pung, and in it he claims Isabella County confiscated the Pung estate's private home for approximately $2,200 in taxes and fees that were never actually owed. How Isabella County handled the Pung estate is truly disturbing. In 1991, Timothy Scott Pung purchased his home located on St. Andrews Drive in Isabella County's Union Township for $125,000. In Michigan, a property owner may claim an exemption from certain local property taxes if the owner occupies the property as his or her principal residence. That's Michigan Law 211.7cc1. This exemption is called the Principal Residence Exemption, or PRE. Like nearly all Michigan property owners with a primary residence, Timothy filed for it and his property was granted the PRE credit, thereby reducing the annual property tax bill. Many states have laws that allow discounts or exemptions for landowners that meet certain conditions, so this law is not the problem. It appears that a single local official is the problem. 14 years later, Timothy unexpectedly passed away, leaving a wife and 2 children without their father. In the years that follow, Patricia DePriest, the Union Township tax assessor, retroactively denied the PRE credit for the Pung property for 2007 through 2011 tax years. After various challenges before the Michigan Tax Tribunal, the PRE credit was ordered to be fully restored. For reasons that are irrelevant to this petition, DePriest decided to, and did, once again, revoke the property's PRE credit for the 2012 tax year. This led to a $2,241.93 unpaid tax bill for a tax that was never actually owed. I know of no law that would prohibit Ms. DePriest from canceling the PRE credit for future tax bills. However, retroactively depriving the credit is not only unjust, but a violation of Article 1, Section 10 of the Constitution, which reads, "No state shall, among other things, pass any bill of attainder, ex post facto law, or law impairing the obligations of contracts." While the tax court agreed with Mr. Pung, ordering the credit to be fully restored, it appears that Ms. DePriest ignored the order and revoked the credit for a different year. But this was not the end of Mr. Pung's nightmare. After more proceedings, the Michigan courts ultimately authorized the foreclosure over Pung's strenuous objections and challenges because DePriest failed to provide timely notice of the 2012 revocation, and Michigan's various tribunals found themselves powerless to fix the error. Based upon the quote-unquote unpaid yet not owed $2,241.93 in tax resulting from the removal of the PRE credit, Isabella County initiated proceedings and effectuated foreclosure. And despite Pung's serious efforts, the Michigan courts would not halt Isabella County Treasurer's demand for foreclosure on a tax never owed. So Mr. Pung's home was foreclosed on, stolen, to pay taxes his family did not owe, based on the dubious revocation of a tax credit for which a tax court had said was valid for previous years. The Union Township, through their tax assessor, failed to provide proper notice of the revocation and allegations of taxes owed, claimed the power to foreclose on property, and the Michigan courts claimed there was nothing they could do. So much for courts of law and justice. The questions Mr. Pung has brought to the Supreme Court are whether taking and selling a home to satisfy a debt to the government and keeping the surplus value as a windfall violates the Takings Clause of the Fifth Amendment when the compensation is based on an artificially depressed auction sale price rather than the property's fair market value, and whether the forfeiture of real property worth far more than needed to satisfy a tax debt but sold for a fraction of its real value constitutes an excessive fine under the Eighth Amendment, particularly when the debt was never actually owed. Now, oral arguments were held by the court on February 25th of 2026.